Good evening, everybody, and welcome to today's virtual session on statutory nuisance. My name is Krishma Patel, and together with Mathew McDermott this evening, we're going to be talking to you about the basics of statutory nuisance claims. We're both housing practitioners based at 42 Bedford Row, and we've provided our email addresses in the last slide. Questions are going to be dealt with by email following this session, so if you do have any questions, please do feel free to send us an email and we will come back to you in due course. Now, with that introduction, can I invite you to have a look at slide number 3, which begins with part 1, which is what is a statutory nuisance? Now, a statutory nuisance is defined within the Environmental Protection Act 1990 in section 79. Section 79.1 actually does contain quite a long list of potential nuisances. For example, smoke emitted from premises, fumes or gas, dust, steam, smell, animals, etc., insects. But by far, the most important section or subsection in that is subsection 79.1a, which says that in addition to those that are specified within section 79, a statutory nuisance will exist in any premises in such a state as to be prejudicial to health or a nuisance. And in terms of that, it's necessary for us to consider what the term "in such a state" means. The Environmental Protection Act, in terms of its purpose, it replaced Part 3 of the Public Health Act 1936. And that act dealt with nuisances and offensive trades. The case of Birmingham City Council versus Oakley, which is a 2001 appeal authority case, sets out that the object of section 79 is to provide for the summary removal of noxious matters. The decision in that case does actually helpfully summarise the law between the implementation of the EPA 1990, and does go through the way in which the legislation developed from the Nuisances Removal Act 1855 all the way through the Public Health Acts and then to the EPA 1990. So you might find that interesting in terms of reading as to the purpose of the EPA 1990. Moving on to the following slide, which is slide 5, in accordance with the definition that is set out in section 79.1a, the premises must be in such a state so as to be prejudicial to health. For example, in the case of Birmingham City Council versus Oakley, which is a 2001 authority that's on the slide, in that case, Mr. Oakley, who was the tenant, made a complaint to Birmingham Magistrates Court alleging that his premises were in such a state such as that they were prejudicial to health, and therefore he alleged that they were a statutory nuisance within the meaning of section 79.1a of the EPA 1990. In that case, the justices found that they were. And it was held that it was unacceptable in the interest of hygiene to expect a person who has used the lavatory to then pass through the kitchen to wash his hands, given the fact that it gave rise to cross-infection. And initially it was ordered that the lavatory was moved into the bathroom with an extractor fan and that the door to the bathroom was resisted. However, the High Court then dismissed the council's appeal, the council then appealed, and the matter reached the House of Lords. And when the House of Lords was considering whether or not the premises fell within the relevant section and were in such a state to be prejudicial to health, it was said that the court must consider some feature of the actual premises which were in themselves prejudicial. And it was said that an arrangement of the rooms which was unsatisfactory and might be considered insanitary did not fall within the provision. And the risk of cross-infection, because the water closet was placed close to the kitchen and the wash basin was in the bathroom on the other side, could not constitute a state of the premises. And therefore, accordingly, it was held that there was nothing in the premises themselves that was prejudicial to health. Now, in the judgment, it was recognised that as undesirable as the arrangement was, it was not permissible to give an extended meaning to the words in section 79.1a of the Act, however socially or hygienically desirable it may be. There's then another case listed on the slide, which is R versus Bristol Crown Court ex parte Everett. And in that case, Miss Everett, the tenant of a 19th century house in Bristol, she suffered from a back injury and as a result had difficulty negotiating quite a steep internal staircase at her premises. She said that the staircase gave rise and alleged that it gave rise and it fell within section 79(1)(a) of the EPA. Now, initially, Bristol Council appeared to share this view and it served an abatement notice on the landlord pursuant to section 80 of the Act. But then the council withdrew that abatement notice upon receipt of some legal advice. When Miss Everett applied for judicial review of that decision, it was held by the court that section 79(1)(a) did not apply to a situation where the only issue was that there was a likelihood of an accident causing physical injury. There was then an appeal to the Court of Appeal by Miss Everett, and the Court of Appeal then held that a risk of physical injury arising from the state of premises did not fall within the meaning of prejudicial to health, and therefore it could not constitute a statutory nuisance. Moving on now to what does prejudicial to health mean? And this comprises part 2 of this talk. The definition of prejudicial to health is set out in section 79(7), which also sets out a number of other definitions that relate to those terms that are used within this provision and this section of the Act. Section 79(7) defines prejudicial to health as injurious or likely to cause injury to health. Now, in the case of the Borough of Malton versus the Malton Farms Manure and Trading Company Limited, it was held that where the state of the premises is enough to cause a well person to become ill or the health of a sick person to deteriorate, then in that situation, courts will normally be satisfied that it is prejudicial to health. It's also noted in that case that premises do not have to be occupied in order to be prejudicial to health. And in terms of the test as to whether or not a premises is prejudicial to health, it's important to note that the test is one that is objective, and therefore the particular circumstances or needs of the person cannot be taken into account. And that is a principle that's derived from the case of Cunningham versus Birmingham City Council. So, for example, in that case, the claimant's son in that case had autism, and it was alleged by the claimant that her kitchen, in view of his condition, was too small and dangerous in the way that it was laid out. And on appeal, in that case, it was held that whether or not premises are prejudicial to health, the question is an objective one. It's not a subjective test. There isn't a contrast with the test for nuisance. The magistrate in that case that was held on appeal had been wrong to determine the case in the way he did by relating the respondent's duties to the particular health requirements of the appellant. Moving on now to slide 9, which is another slide dealing with what is the meaning of prejudicial to health. The EPA doesn't actually define what is meant by health, but it will include both physical and mental health, including, for example, depression and anxiety. And it will also cover things like a threat to health, for example, the risk of disease or illness. For instance, in a few cases that I've been involved in involving damp and mold, you will usually get an expert report that describes the occupants of a mouldy property and the fact that they will be exposed and inhale things like spores that can then pose a threat to the health of the occupants, increasing the probability of them experiencing health problems. An expert report also will identify if there are occupants in that property that are more vulnerable, for example, those with compromised immunity, or children, for example, those with underlying health problems, and the risk of developing health conditions as a result of damp or mold or whatever the issue is. There are also some examples on this slide of what has been held previously to not meet the threshold of being prejudicial to health. For example, the case of Salford versus McNally, in that case, the House of Lords considered the interaction of the Public Health Acts 1936 and 1957 as to the distinction between the questions of injury to health and fitness for human habitation. And in that case, it was held that health is not the same as comfort and interference, and the latter does not bring a case within the health limit of the Public Health Act. Similarly, in the case of Springett versus Harrold, this was a case in which the divisional court dismissed an appeal against a decision of the Metropolitan Magistrate that a lack of internal decorative repair, even if it caused discomfort and inconvenience to the tenant of a house, did not constitute a nuisance within the Public Health London Act 1936 pursuant to section 82. Another example of this is the case of Coventry City Council versus Cartwright, and in that case it was held that an unsightly rubbish tip that did cause an eyesore was not something that fell within the definitions and was not something that was regarded to be prejudicial to health. Moving now on to slide 10, which provides a couple more examples of what has not met the threshold of being prejudicial to health. For instance, in the case of R. Wakey versus Haringey Magistrates Court 2003 authority. In that case, a tenant's dissatisfaction with his accommodation arose from his concern that the premises were too close to a railway line and there was no proper insulation or double glazing to protect that tenant and his family from the noise nuisance. And therefore, he alleged that it deprived him and his family of peaceful enjoyment of their property. But in that case, the expert report didn't show anything but amounted to evidence that the noise from the traffic on the railway line was actually prejudicial to the tenant's health and his family's health. And in another case, the case of R. Vella versus Lambeth Met Council and LQHT 2005 authority, High Court, in that case, the claimant tenant had applied for judicial review of a decision of a defendant local authority not to serve an abatement notice requiring noise insulation works to be carried out by the landlord. The tenant who lived in a flat of a converted house complained of noise transference from the flat above him and also from the communal areas. The tenant contended that the noise constituted a statutory nuisance under the EPA section 79(1). It was held that a lack of adequate sound insulation could not cause the premises to be in such a state as to be prejudicial to health for the purposes of section 79(8). So those are just a few examples. There are, of course, many other examples in terms of the case law of what has been held not to meet the definition or be considered prejudicial to health within the meaning of the EPA. There are some examples, however, on slide 12, the following slides, just general examples of things that have been found very commonly to be prejudicial to health. For instance, damp, condensation or mold growth, or infestations, for example, rodents, cockroaches, insects, etc. It is important to note that in the cases, for example, of damp or condensation or mold growth, it has been held that a landlord isn't liable if the problems occur because a tenant has failed to use their heating system properly. And that is a principle that derives from a case called Pike versus Sefton NBC 2000 case in the Queen's Bench Division. In terms of how to answer the question about whether or not a premises is in a state that is prejudicial to health, expert evidence is needed, and that is something that is made very clear from the case of Southwark versus Simpson. Now, the case of Southwark versus Simpson provides that expert evidence is needed, and in that case, the applicant alleged that condensation and mold growth was a statutory nuisance by reason of the fact that it was injurious to health. The Magistrates Court in that case heard from a chartered surveyor on the point of whether or not defects of structural character had caused nuisance, and as to the nature of those defects. At the end of the cross-examination of the chartered surveyor, he was asked specifically whether the mould and the damp which he had seen was likely to actually cause injury to health. And he prefaced his answer by saying that he had no medical experience, he had no medical knowledge, but that he had read articles which indicated to him that that was indeed the case. Now, he didn't produce any of those articles, and nor was he able to apparently give any details of them. And in those circumstances, it was held that where the submission was made on behalf of the appellants, there was no expert medical evidence linking the state of premises to the issue of prejudice to health. And in the absence of such evidence, it was not open to the court to find that such premises were in such a state to be prejudicial to health. That was a submission that was accepted. And it was held that it isn't necessary for a witness on the issue of prejudice to health to have a medical qualification, but it is necessary for the witness to have some experience or expertise in the particular field. So, for instance, an experienced surveyor could be a proper person to give evidence on the issue if, in the course of his duties as a surveyor, he had considered the relationship between damp and mould and injury to health. But in this case, specifically in Southwark versus Simpson, the surveyor had disavowed any experience or expertise in the particular field, and accordingly, the magistrates were wrong to allow him to give evidence. And that was what was held on appeal. And it was also considered as part of that decision that a properly qualified expert is entitled to rely upon evidence which might otherwise be considered hearsay, and that is to say, findings by other experts in the same field in support of an opinion of any given set of facts. And so what we get from that case is the fact that medical evidence is needed, but it's not. But medical qualifications aren't necessarily needed. But experience is absolutely required. Moving on to the next slide, this just follows on from the previous slide. So, if an individual has experience in the course of their work, that may well suffice. Environmental health officers are more likely to have this experience. So, for instance, in the case of O'Toole versus Knowsley, 2000 authority heard in the Queen's Bench Division, this was an appeal about a decision that premises were not in a state prejudicial to health or a nuisance under Section 79(1)(a) of the Environmental Protection Act 90. Evidence had been excluded as to prejudice to health given by former environmental health officers acting as consultants on the grounds that whilst they were competent on the condition of the premises, they could not give expert evidence on the occupier's state of health. And the court in that case accepted the appellant's admission that it wasn't necessary for the environmental health officers to possess medical qualifications in order to express an opinion as to whether or not the premises were prejudicial as defined by Section 79(1)(a) of the Act. And the finding in that case was that the environmental health officers possessed appropriate knowledge and expertise which the justices did not have. And by refusing to accept the evidence of those witnesses, the justices substituted their own view on the issue, which they were not entitled to do, and therefore the appeal was accordingly allowed. And finally, it's important to remember that the definition in Section 79(1)(a), which is sort of the catch-all definition before the specific list is given, that is a statutory nuisance is defined of any premises in such a state to be prejudicial to health or a nuisance. Now, in terms of that bit, or a nuisance, there are, of course, two types of nuisance, public and private nuisances, and we, for these purposes, are concerned with a private nuisance. And in the case of NCB versus Thorne, which is a 1976 authority at page 546 of the decision, a nuisance is private nuisance is described as interference for a substantial length of time by owners or occupiers of property with the use or enjoyment of neighbouring property. And it's important to note that private nuisance concerns harm to people and not property, and it is likely to include things like unreasonable, unacceptable interference with amenity or personal discomfort. Now, of course, this was a very short and concise introduction to private nuisance. Just on this slide, and there is a lot more reading and a lot more principles that derive from case law, but unfortunately, there isn't enough time to talk about all of that today, but I would encourage you, if you're interested to learn more about it, to do some more background reading, or of course to send us an email if you'd like to do so. That has been a short whistle-stop tour that I've given in terms of the first two elements of this talk. I hope that it has been helpful to you. If there are any questions, please do feel free to email us at any time after this talk, and we will endeavour to get back to you in due course. That concludes my section of the talk, and I will now pass you over to Mathew to deal with the following two other sections of the talk. It's been a pleasure to present to you, and thank you very, very much for tuning in.
Thank you very much, Krishma, and hello to everybody watching. I'll be dealing with the second part of this training, seeking to split it up into two separate sections. So part 3 is focusing on defences, which is really just another way of focusing on what it is the prosecutor needs to prove, failing which the offence won't be made out. And I'll go through all the hurdles that the prosecutor needs to jump And then after defences, the final section, part 4, deals with what it is the Magistrates Court can actually award and the different elements of, if you like, a court order. So starting first then with defences, what it is that the prosecutor has to prove. Section 82, subsection 2, and I should say that whenever anybody is referring to the legislation, you'll see a lot of reference to Scotland and terms like defender and the sheriff, which don't apply to England and Wales, and obviously our training is just of application to England and Wales. So I'm paraphrasing the legislative provisions and missing out bits that aren't of direct relevance to England and Wales. If the Magistrates Court is satisfied that the alleged nuisance exists, or that although it is abated, it is likely to recur on the same premises, the court shall make an order for either or both of the following. And I'll come on to the order that can be made in part 4. Effectively, that's about works that are needed to abate the problem or indeed to prevent it from recurring. But that, at section 82, subsection 2, is in a nutshell the offence, that the alleged nuisance exists, or that although abated, it is likely to recur on the same premises. Now, if we move on, section 82, subsection 4 refers to proceedings being brought against the person responsible. So if you like, this is the guilty party. Subsection 4 says, proceedings for an order under subsection 2, which is the subsection we've just referred to, shall be brought A, except in a case falling within B, C, or D, against the person responsible for the nuisance. And that is in relation to a statutory nuisance, and as Krishma has made clear, that's what we're talking about in the landlord and tenant sphere that this training is built around. In relation to a statutory nuisance means the person to whose act, default, or sufferance the nuisance is attributable. So in a very obvious example, the person who has failed to remedy the roof, resulting in a leak that is then constitutes a statutory nuisance. But there are two other scenarios, if you like. The first one there is the person whose act, default, or sufferance the nuisance can be attributed. But then we have 2 and 3 on the following slide. I'll jump to the third one, which is C, simply because it's not likely to come up very often. Where the person responsible for the nuisance cannot be found against the owner or occupier of the premises, and that is in 82(4)(c). But on the reasonable assumption that that won't come up very often, we're really looking at the first scenario that I've just highlighted, or B, where the nuisance arises from any defect of a structural character against the owner, 82(4)(b). And obviously in cases concerning premises, residential accommodation in particular, then that can be of application. So that's who one is focusing on. And that's what the Act means when it refers to person responsible. Now, moving on to the next slide, these are a few examples of how that concept has been addressed in the courts. So one example is where the complainant, the prosecutor, if you like, has prevented works from being undertaken. Now, this case of Quigley and Liverpool Housing Trust from 1999 that I put there on the slide was a case where the occupier didn't want to move out to alternative accommodation to allow the works to be carried out. And so the court couldn't be satisfied that it was the trusts, Liverpool Housing Trusts, act, default, or sufferance that the nuisance was attributable to. or to put it in more simple terms, wasn't satisfied that it was it that was the person responsible. Another example, which has arisen in one or two cases, is where heating, which was provided but wasn't used due to its expense, resulting in condensation damp. And that comes from the case of Dover District Council and Farrar. And in a similar vein, there's the case of Carr against Hackney London Borough Council of 1996. There was the issue arising out of the second element of the offence, which is the likely to recur element. Putting aside whether or not it's present, there's also this issue of whether or not it's likely to recur. And that's what was live during this case. And that was really the issue only because the tenant wouldn't let agents in to fit a particular heating system, because a different system, a gas heating system, was wanted because that was going to be cheaper to run. And again, it came down to this issue of whether or not the authority, in that case Hackney, could be reasonably seen as the person responsible. And the court found that the answer to that question was no. Now, that point can't be taken too far. What I've highlighted on the next slide, with reference to the Greater London Council case against Tower Hamlets, the key point is causation. And if you're looking at it from broad stand-back principles, you're really asking who or what is it that's caused the nuisance. So you can't simply say deny liability in condensation dampness cases, for example, and Krishma's made that point already. Landlords will need to be aware of the need for heating, ventilation, and insulation, as the facts may warrant in any particular case. The next slide is moving on to a slightly different topic concerning the importance of ensuring that there is a valid abatement notice. So in section 82, subsection 6, there is the statutory requirement to serve a notice, a 21-day notice, that effectively summarises the complaint and gives 21 days, gives a 21-day period during which it ought to be abated if not proceedings can be instigated. Subsection 6 says that before instituting proceedings for an order under subsection 2, which is the slide that I started on, against any person, the person aggrieved by the nuisance shall give to that person such notice in writing of his intention to bring the proceedings as is applicable to proceedings in respect of a nuisance of that description, and the notice shall specify the matter complained of. Now, the first case that I've referred to on this slide, involving East Staffordshire Borough Council, is an example of a case where the notice was challenged, the content of the notice was challenged, but the challenge was not upheld. And one of the things that was discussed was that the notice doesn't need to say what the person responsible, the recipient, needs to do, the works that must be undertaken. Subsection 6 simply says that the notice shall specify the matter complained of. So that's what one is looking for, a notice that gives 21 days to abate the alleged nuisance, and it specifies the matter that is effectively comprising the alleged nuisance. Alternatively, there is the requirement that one serves, or at least the requirement in the matters that we're discussing, a notice that gives 21 days to abate the nuisance. So clearly, if the period of time is less than the statutory period, then the notice would be defective and there would be a defence there. So we've got content, we've got period, and then you've got the simple question, or at least one might think the simple question of service of that notice. In particular here, leaving behind section 79, which defines the nuisance, and section 82, which is the offence and matters relating to the offence, and the order in particular, Section 160, in particular subsections 2 and 3, talk about service. There's the recent case of Allen against the London Borough of Ealing, where the notice, the abatement notice, was addressed to, quote unquote, the London Borough of Ealing, but it didn't refer to clerk or secretary, which you'll see, for example, in 160, section 160. It didn't refer to the housing department, or it didn't refer to a particular solicitor. But the High Court, overturning the decision of the Magistrates Court, that found in the case of a body corporate, here the London Borough of Ealing, that was good service. It was addressed to the London Borough of Ealing, and the court found that it had been received, and there was no requirement to serve it on the clerk or the secretary or indeed the CEO. So another thing that the prosecutor has to prove, if you like, another defence, moving away from the form or content or service of the abatement notice, is simply that they are, as Krishma's already talked about, the person that's aggrieved by the statutory nuisance. And this is quite nicely illustrated by the 2019 case that I referred to on this slide of Watkins, where there was some disagreement over the status of the occupant, but importantly, by the time the matter came before the magistrates, a possession order had in the county court, I believe, already been made against the property, against the complainant in the criminal proceedings. It hadn't been executed, so they were still in occupation. But it was argued that effectively that person was now, if not always been, now trespassing. The court in Watkins said it's a fact-specific question. It's really a matter of fact and degree, whether or not the person aggrieved whether or not the complainant is a person aggrieved. But in that case, it was said that they could be. And the other point that will have been noticed from, and I'll come on to this in a bit more detail, section 82, subsection 12, is where the nuisance has been abated at the date of the trial. Effectively, if that's the case, the offence is not made out. That, however, doesn't mean that it will be the end of the matter from the defendant's point of view, and that involves talking about the question of costs and or compensation, which I'll come on to. But the point being that if at the date of the hearing the nuisance is abated, then the offence has not been committed. And what I've got on the next slide, and indeed the slide that follows that, is just a brief, basic but hopefully helpful checklist of matters that you go through to see the necessary ingredients of this offence. So you start off with the notice, the abatement notice, then you move on to the bringing of the proceedings, the laying of the information in the Magistrates Court. And the offence, as Krishma was saying, refers to the premises being in such a condition as to be injurious to health or likely to cause injury. And then we have those other matters that I've just been discussing. Is the defendant the person responsible in the different manifestations of that phrase? Is the person complaining, the person aggrieved, which is not as simple as simply saying they are the tenant who have a contractual or maybe statutory right to occupy. It can be broader than that. And then at the date of the hearing, does the nuisance exist or is it likely to recur? That's really what one needs to go through to establish the ingredients of the core ingredients of the offence. So moving away from that matter and moving on to the final part of this presentation, what is it, if the offence is proven, can the magistrates actually award? And I've labelled these in the four separate headings, and the fourth one I'll focus on quite a bit. There's an abatement order, fine, compensation, and costs. So obviously the thing that the magistrates can order under section 82, subsection 2, which I've already referred to, is an order aimed at addressing the problem. And the problem is going to be something relating to the condition of the property. And it can be one or both of the following: an order that requires the defendant, within a time that is specified in the order, to execute any necessary works for the purposes of abating the nuisance. So that's one element of a possible order. But then it could also be, or indeed instead of, it could be this: an order prohibiting a recurrence of the nuisance within a time specified in the order, if those works are necessary to prevent that recurrence. So it can be one or both of those, whether it's abating the nuisance that is present, or if it's taking works to prevent it from reoccurring. Now, at this point, the courts will want, or at least benefit from, evidence on this. So normally there'll be a report that with scheduling what it is that needs to be done, precisely the works that need to be done, and then also, of course, the time period in which one can expect those works to reasonably take place. Moving on to the next slide. A lot of people who work in this area are very familiar with Section 11 of the Landlord and Tenant Act 1985, which imposes certain repairing obligations upon landlords of most short leases. But an argument that is often had in those proceedings regarding the distinction between repairing something that you're supposed to keep in repair and improving something is not an argument that necessarily will take place in these criminal proceedings, because here the abatement order may include works of improvement. It's not necessarily just about repairing the thing that has caused or contributed to the nuisance. So there's the case of Kelly against Birmingham from 1985, where the authority in that case was ordered to install central heating in order to abate serious mold growth. And it's fair to say that that's probably an order that wouldn't apply in most County Court Section 11 proceedings, because it's evidently an improvement. But here the focus is on abating that nuisance. And if the condition of the property is such that the court believes it to be unfit for human habitation, then actually they can order that occupation of it, of the property in question, is to, or prevent occupation of it until it becomes fit for human habitation. That's in subsection 3. Before I move on to fines, sorry, that's in subsection 3 of section 82, which says that if the Magistrates Court is satisfied the alleged nuisance exists and is such as, in the opinion of the court, to render the premises unfit for human habitation, then an order under subsection 2 may prohibit the use of the premises for human habitation until the premises are, to the satisfaction of the court, rendered fit for that purpose. So that's the matter of an abatement order. Then the court also has the power to impose a fine, which comes under subsection 2 of section 82, which makes it clear that the fine, or a fine I should say, sorry, may be imposed. Now, obviously, if there's no nuisance at the date of the trial, which means it's not proven to exist or it's not likely to recur, then there won't be a fine. This is a consequence of there being an offence having been committed. And in this scenario, the offence has not been committed, so there's not a fine. There is an important issue there that I'll come on to in relation to costs. In other words, what happens when the offence isn't made out, but costs have been incurred, and I'll move on to that. But the fine is different. There was, at least in England and Wales, up until a few years ago, a maximum fine that could be imposed, but since 12th of March 2015, that maximum has been removed. And then what I've put on this slide and the slide that follows are some factors from this case from 2001 involving Yorkshire Water Services Limited that will be taken into account when assessing the level of the fine. And most of these are what one would expect to be the sorts of factors impacting upon the amount of the fine. The degree of culpability involved in the commission of the offence, the damage that was done, whether the defendant has any previous record. There's this need to strike a balance between a punishment, if you like, but then not being too counterproductive, imposing too great a financial penalty. Of course, always relevant is going to be the defendant's attitude and performance, perhaps attempts to address the problem, reasons why it couldn't be addressed as quickly as one might have hoped. And central to that is going to be whether or not there was a guilty plea. And finally, if the facts warrant it, then the duty of the court to determine what the penalty for any one instance should be, rather than to tot up all the various manifestations of that incident. Thirdly, we have compensation orders. Now, the power here comes from section 130 of the Powers of Criminal Courts, brackets sentencing, close brackets, Act 2000, and the convicted person may be ordered to pay compensation. And this could be relevant for any personal injury, something that Krishma has already talked about, loss, any damage that results from the offence. I've included an extract here from a very authoritative book of law and procedure that's used in the Magistrates Court, Stone's Justice Manual. Has some commentary on section 130 of the 2000 Act. The machinery of a compensation order under this Act is intended for clear and simple cases. It must always be remembered that the civil rights of the victim remain, although the power to make a compensation order made by the court of trial can be extremely beneficial, as long as it is confined to simple, straightforward cases, and generally where no great amount is at stake. And this case of Davenport and Walsall is a good example of that, where the court declined to make a compensation order because the correct venue for deciding the amount of compensation was the county court. And that may well be because in any given case, there might be a cause of action under section 11, as I've already talked about. The damages in the case were not easily quantifiable and were accordingly not within their discretion. A similar example is found in the Horsery Road Magistrates Court case that I've included on the next slide. The court determined that compensation should only be awarded in cases which are simple and straightforward and where no great amount is at stake. So you might have complex or indeed serious personal injuries where it might be a time-consuming and intricate exercise to undertake quantification of damages, or at least what the civil practitioner might refer to as damages. This procedure is not aimed at those sorts of assessments. And a couple of other points dealing with the question of period, in other words, how long are we looking at when it comes to these compensation orders? They are confined to the period from the date of the summons to the date of the court's decision. And referring back to the abatement notices that emanate out of section 82, subsection 6, no complaint can be made until that notice is expired. So really it becomes a matter of jurisdiction. There is no jurisdiction to make a compensation order in respect of any period before that date. Finally, technically not moving away from compensation, but in substance we have this question of costs. Now, costs come out of subsection 12 of section 82. And it may well be, if you're familiar with these prosecutions, you'll have experienced that many of these prosecutions are now, at least, brought on pursuant to contingency fee agreements, and they're recoverable. The costs incurred pursuant to those CFAs are recoverable. There's certain restrictions on costs generally, and I'll come on to them, but as a principle, they are. And as I say, subsection 12 is really key here. So I'll read out subsection 12. When on the hearing of proceedings for an order under subsection 2, which is loosely speaking the abatement order, it is proved that the alleged nuisance existed at the date of the making of the complaint or the summary application, then whether or not at the date of the hearing it still exists or is likely to recur, the court shall order the defendant to pay to the person bringing the proceedings such amount as the court or the sheriff, in Scotland, forgive me, here of course we're just talking about the court, considers reasonably sufficient to compensate him for any expenses properly incurred by him in the proceedings. So you'll see there from subsection 12, the word compensation is still employed. To pay to the person bringing the proceedings such amount as the court considers reasonably sufficient to compensate him for the expenses properly incurred. And I've highlighted what I believe are the key elements there of subsection 12 on the following slide. A couple of points to note here. I've already discussed the requirement of the abatement notice, and in these types of statutory nuisance prosecutions, the 21-day requirement. Costs can't be resisted by suggesting that it was impossible to carry out the works by the date required by the notice. And very recently, it was stated, in fact, it was repeated, that the assessment is broad brush. Subsection 12 is the power that the magistrates have to order the compensation, or the cost, if you like. That is the basis of the assessment, and it's a broad brush approach. But the costs which can be recovered can include expenses incurred in proving the existence of the statutory nuisance. So that may be the environmental health officer, for example, whose report, or the expenses of that report, and the report is the primary evidence that has proven the nuisance, and any expenses incurred in carrying out the steps required by statute prior to the making of the complaint, which a good example, an obvious example, is the costs incurred in serving that abatement notice pursuant to subsection 6 of section 82. Now, that is the end of the presentation. I've effectively sought to identify the key ingredients of the offence, and from that, the defences that can be employed to prevent the offence being made out, and then the powers that the magistrate courts have, whether it's focusing on addressing the problems or compensating the complainant, or indeed arguing over the costs that allegedly have been incurred reasonably bringing the proceedings. If you do want to know more, as Krishma has already said, if you have any questions, then our emails are there on the final slide, and you can also follow the housing group at 42 Bedford Row on Twitter, and we have a housing law bulletin, and there's a way there of accessing the bulletin. I hope you've enjoyed and hopefully benefited from the presentation. And as I say, if you do have any questions, please feel free to contact either Krishma or me. Thank you.